22nd of July 2025. So on the 1st of July 2025, the UK government published a statement of changes, HC 997, confirming a major shift in the country's immigration policy. These changes are the first set of reforms giving effect to the government's earlier promises in the UK Immigration White Paper 2025. So I'm sure we all remember the white paper. There was a lot of uproar about the white paper. Some viewed it as threats from the government of what was to come. So these new changes come from the 22nd of July 2025. These are the first set of changes that the government said to put in place. So the new rules will apply to all skilled worker visa applications, including significantly higher salary thresholds, tighter rules on dependents, a return to degree level requirements, and the introduction of two interim shortage occupation lists. The care sector also faces a major restriction with overseas recruitment into care roles ending entirely. Now, this is a big one for most of us as it applies to most of our clients. So today I will explain what's changing, when it's taking effect, and how to prepare ourselves for what's to come. Right. So the first major change that we're going to discuss is that the skill level has raised to degree level RQF6 plus. So from the 22nd of July 2025, the minimum skill level for jobs under the skilled worker route has been raised from RQF3 to RQF level 6. So this reverses the post-Brexit decision in 2020 to lower the threshold, and it opens the route only to graduate level occupations or those that have been listed in the new shortage lists. So, as we all know, for some of the skilled worker jobs, for example, nurses, you didn't quite need a degree for you to be able to qualify for the visa. You could just get a diploma or certificate from a recognized institute, and you'll be able to qualify for the visa itself. So this has been changed, and it reverses the post-Brexit decision. And now, for you to be able to get a skilled worker visa, you now require a degree level qualification or RQF level 6. The Home Office estimates this change removes over 101 occupations from the general eligibility. So such occupations as chefs, hotel managers, hospitality supervisors, bricklayers, carpenters, and construction trades, retail and warehouse managers. These are the occupations that are going to be removed. Um, but however, occupations below the RQF6 may still be sponsored only if they appear on the expanded immigration salary list or the temporary shortage list. So there are jobs that will still be able to be sponsored as long as they appear on the temporary shortage list and the expanded salary list. This I will also touch on as we go through the presentation. Um, the second major update is the updated salary thresholds. All new certificates of sponsorships issued on or after the 22nd of July 2025 must meet the new salary level based on the 2024 annual survey of hours and earnings data. Um, so as if it wasn't hard enough to sponsor someone, now the requirements for sponsorship have also changed, and now there's a higher salary threshold. This makes it harder for sponsors to get people from outside the country to come in and work, as there are people in Britain itself who are not even earning that much. So this encourages sponsors to hire locally other than internationally. So that's an area of concern for skilled workers, but there is also no transitional exemption for salary. Even the existing skills workers must meet the new salary levels at the next extension or employer switch. So those who are currently on a skilled worker must also meet these exemptions when they decide to extend or when they decide to switch their employers. But however, the good thing is that the law does not have a retroactive effect. So if you're on a skilled worker right now, this doesn't apply to you. This only applies to those who will be extending their skilled worker visa or those who will be switching to a new employer. And keep in mind that will be in effect from the 22nd of July, 2025. So below, as you can see on the screen, you can take a picture of this, or you can jot it down or take a screenshot. It's the salary threshold for all sponsored work. As you can see, the general threshold will be shifting to 41,700 and and so on and so on. So you can take a picture of this, and or you can take a screenshot so that you just keep it and you can always go back to it just for clarity. Okay, and the third major change that's going to be coming into effect on the 22nd of July 2025 is that care workers are no longer eligible for the skilled worker route. Now, this is major for most of our clients, and I know for most of you who are here attending this webinar today, this is a major one for you. So this basically says it's the end of overseas recruitment. From the 22nd of July 2025, care workers and senior care workers can no longer be recruited from overseas. These roles will be removed from immigration salary list on the 22nd of July 2028, and the COS cannot be assigned for new out-of-country applicants to this date. So um, this has been done because there's been a lot of abuse when it comes to the care worker route and with regards to obtaining visas coming through the care worker route. We have had a lot of people who've obtained visas and they come to the UK and there are no hours available for them. We have had people buying COSs. We have had people being scammed through this. So in order to cut out these abuses and in order to also uh, create jobs locally, the government has decided to end the care worker route. So as from the 22nd of July, 2025, care workers and senior care workers can no longer be recruited from overseas. However, as stated earlier, the law does not have a retroactive effect. So this means that this only applies to new applicants and those who are already on a skilled worker visa. This does not apply to you. But however, these roles will be removed from the immigration salary list on the 22nd of July, 2028. And so as cannot be assigned to um, any new applicants. But those who already have the application, the visa itself can still continue to enjoy the same rights that they were enjoying before this law came into effect. So turning to that, in-country switching. This is for those who are already in the country and who already hold the visa. Switching into these roles is allowed only for workers already in the UK and who have been working for at least 3 months prior to their COS being issued, and only until July 2028. So after July 2028, that's the end of it in terms of care workers and senior care workers. I know a lot of people are going to have a lot of questions about this. Please do put them in the chat, and please do save them for when we do have our question and answer session after this. So these changes follow the government's concern over exploitation of overseas workers. This we have seen a lot of. Non-sponsor compliance. Sponsors have also not followed the rules and regulations when it comes to sponsoring workers from outside the country. And as a result, we're seeing the curtailment of the care worker visa and also the unsustainable use of sponsorship in adult social care. So, as a result, sponsors must retain evidence of lawful employment and meet all compliance requirements during the transition period. The government has, however, set up a temporary shortage list. This includes jobs at RQF level 3 to level 5, identified by the Treasury Department and Department of Business and Trade as important to modern industrial strategy. So the government has also set aside jobs that they think are very crucial to the UK economy and to the UK in general. And these jobs people can still apply to even if they don't have the required RQF level 6, which is the degree. So you might have a diploma or a certificate from a recognized institution. You can still apply for such jobs. Uh, Here is a full list of the eligible occupations on the temporary shortage list. You can just go through it, take a picture, take a screenshot so that you can refer to it later on for those of you who would want to apply or who qualify for such jobs. So I think there are like 4 slides on the full list. So I'll just be going through them so you can take pictures and take a screenshot of this.
When we can't hear you.
All right, now I was just giving people an opportunity to take a screenshot of the list of the current temporary shortage list. All right, so moving on, the other major change that has been that is coming into effect on the 22nd of July 2025 is that there will be
Sorry, we didn't
no more.
see. Sorry, we didn't see the shortage list of the where you're supposed to take the screenshot.
All right, let me just go back to the list. Okay, there it is. So please take a picture of this or a screenshot so that you can refer to it. You can also find the list on the official government website. That's gov.uk. The list is also there. Okay, so moving along, for those who still want the list, you can find it on the official government, which is gov.uk. The list is available there. So the next major change that we're going to see come into effect on the 22nd of July 2025 is that there will be no more dependent rights for sub-degree uh, shortage roles. So from the 22nd of July 2022, the 22nd of July 2025, applicants sponsored on the RQF 3 to 5 roles will not be allowed to bring dependents. Um, this I know is a big issue for most of our clients as well. But this policy, the good thing is that it does not apply to existing visa holders who are already sponsored in these roles, and it does not apply to occupations at RQF level 6. These are and above. These are degree level jobs, and also children born in the UK or in cases of sole parental responsibility. Um, this extends the existing dependent visa restrictions applied to care workers across broader skilled worker routes. So this is also an extension of existing visa restrictions that were applied, some of that were applied in March 2024. This is just an extension of that. So as from 2022, as from 2020, 2022 July 2005, applicants were applying for these roles in the RQF3 to RQF5 roles will not be allowed to bring dependents. So this is another big issue. Again, this is because of the abuse that the government has seen over the years. When it comes to bringing dependents, there's been issues of people bringing people who are actually not their dependents to the UK. For the sake of it or because they can add people as dependents on their visas. So as a result, the government has put an end to it. And again, they are referring to it as restoring order. So again, it just shows what the abuse of the law and the abuse of this route itself has resulted in. Um, Home Office has confirmed that additional changes are coming later this year, including an increased immigration skills. Sorry about that. So the Home Office has announced that more changes are expected later this year, and this includes stricter English language requirements, an increase in the to the immigration skills requirements, a new family migration policy, and employers should monitor upcoming changes and plan for fee increases, potential changes to the visa, UK eligibility criteria, and updates to other routes such as graduate visa and global talent visa. So again, these rules do not apply they only start applying to you when you want to change your visa or when you want to extend your visa. That's when it will start applying to you. So there's been a lot of panic of people asking, does that mean that we're being sent home? Does that mean that my visa is coming to an end on the 22nd of July? No, it does not. So if you have your visa and you're currently working and your visa is not expiring anytime soon, there's no need for you to worry because these laws do not apply going backward. They only apply going forward. So what should employers do next for those employers who want to bring people to the UK via sponsored work? Um, the first thing that they should do is make sure that workers meet the new thresholds, the salary thresholds from the 22nd of July 2025, as there are no exemptions. So employers, when you're bringing in new people from outside the countries, you should make sure that they meet the 41,700 salary threshold, which is required. This does make it a bit difficult to bring more people into the country, but essentially that's the reason why they've put in place these rules. Um, there's also an update to the job roles or descriptions. Employers have to make sure that they clearly state um, that the requirements for the jobs are RQF level 6, and those who do not have an RQ level 6 are no longer eligible unless they appear on the temporary short list. Employers should also stop offering dependent support. So for employers, those who are offering dependent support, they should remove references to dependents for any role that won't qualify under the new rules. Employers are also supposed to train HR teams, ensure HR compliance, and that teams understand the new salary rules, certificate of sponsorship updates, and the new shortage occupation lists. Employers must also monitor specific changes, especially if you operate in adult social care, construction, creative industries, or skilled trades. Employers must also prepare for future reviews. The government has stated the ISL and the TSL, which is the temporary shortage lists, will be removed after 31 December 2026, except for care, which is reviewed separately. So after December 2026, the jobs that we showed earlier, which are on the temporary shortage list, will be removed, or either the government will review the list, whether they decide to keep it or add more jobs or remove other jobs, that's yet to be seen. But as of now, these are the major changes that are set to take effect on the 22nd of July. So please take note of the important dates, mainly the 22nd of July 2025 and the 22nd of July 2028. As 22nd of July 2028, that's when uh, the care worker roles and the senior care worker roles will no longer be recruited from overseas completely. So those are the two major dates to take note of. And these are the major changes that are coming to effect on the 22nd. So I'm just going to rush through them so that we do a quick recap, and then after that we can go ahead and have our question and answer session. So the first change that we said is taking place is that the level of qualification is being raised to a degree level, which is RQF 6 plus. And the second change is the update to the salary threshold, which is raising to 41,700 as of 2020, as of 22 July 2025. Um, for those who hadn't taken a screenshot of this, you can go ahead and take a screenshot of this. This is the salary threshold for the sponsored work. And the third major change that we said was going to take place was the end of care work recruitment from overseas as of 2022 July, as of 22 July 2025, and also the end of care work in general as of 22 July 2028. The fourth one was the shortage list. So the shortage list, as stated earlier, these are jobs that the government feels that the UK cannot do without as of now. So these are jobs the way you can still apply if you do not have a degree level or if you have a diploma or a certificate from a recognized institution. And um, the list is there for you to be able to find on gov.uk. So you can still find the list of jobs that are there on the temporary shortage list. um, Also, it's good to just go on the list and read the documents for yourself so that you also have an understanding from your own perspective. So on the on the website on gov.uk, there's also an explanation memorandum. It's a 12-page document whereby they'll be explaining all the changes. So you can also just download it and keep it for your own reference later on. And it's a very simple document. They've tried to make it as simple as possible for everyone to be able to read and understand the upcoming changes. So if you need any help, we're here at Tulia. We can help you. You can find us at tulia.org.uk. You can find us on our WhatsApp number, which is there, and you can also find us on our. You can also call us on our landline in the office. We're always here to help. Take any questions. You can also book a consultation on our website, which is www.tulia.org.uk, and we can always give you trusted legal advice. Please do look for a lawyer or get legal advice from a professional, as there have been so many videos and so many explanations from different people as to what's to take effect on the 22nd of July. There's also been a widespread of misinformation. So please, if you do have any questions or feel the need to get any legal advice or any immigration advice, please do contact us on our contact details at tulia.org or on our WhatsApp number, which is there on the screen, and our telephone number, which is there on the screen. All right, I think that's all from my side. Margaret?
Thank you, Wayne. Yeah, so now we're going to go ahead and just answer some of the questions within the chat. So some of you guys have popped some questions in there, and we are just going to ask both Arslan and Rumbi to just help assist and to answer some of those questions for us. So one of the first questions is someone has asked, what about your sponsor you have never worked for? However, your license is still valid. What kind of happens to them? So I'm going to ask if Arslan can just assist with answering this question.
Could you repeat the question for him?
So someone has asked, they're working for their sponsor. However, well, they came on a sponsor, but they've actually never worked for them. However, the license is still valid. Would this affect them?
The best thing to do in these circumstances is always, if this occurs, make sure you look for another COS where your visa can be valid, because technically, if you're not working for the company, you would be in breach of the immigration rules.
Thank you.
So perhaps just to add to that as well, if like Austin said, that if you're not working for your sponsor, then you can also lose your right to remain if you encounter the Home Office and you haven't done anything about it. So you're worrying about, you've asked about what should happen to the sponsor, but what also will happen to you. So you need to take some action around that, looking for a new sponsor, but also showing your communications with your sponsor in an effort to work. And if the Home Office does become aware of it, the sponsor license will be revoked, but also your leave to remain can be curtailed. And at times, the Home Office will curtail it immediately without giving you even 60 days or anything. They can instantly cancel it because you're also in breach, because you're not working. And if you're working somewhere else, then you're in breach of your conditions again because you're working illegally. So it's really important not to just stay in that situation and think that I've got a visa for 5 years, but you're working in a butcher or you're working as a cleaner, like in a car wash. Because if you are encountered by the Home Office, they will cancel your visa straight away and remove you, which they are doing to many people that they're encountering in those circumstances. So immediately find a job, but also you may have recourse against your employer if you've been trying to get work and they haven't stuck to their side of their contract. So I'd also seek advice around that. You can come to us or you can go to there's quite a lot of organizations who are advising displaced workers. So seek advice for your situation as well around that, around the employment law and the immigration consequences of that. So the Work Rights Centre as well in London, if you're in London, they also would be able to advise you, especially around employment law, because they've got a team around that area.
Perfect. Thank you, Rumbi. Thank you, Arslan. Yeah, so we've got another question. So this one is more so someone just wants a clarification. So they said, what do you mean by at the end of 2028? That's the end of it for workers and care workers. And they've asked the end of what exactly, switching or the visa itself? Arslan, if you just want to assist with this question, please.
So the new changes that have came in, they are affecting dates up until 2028, which means after that, they are not intending to have any further care workers from abroad. Currently, entry clearance applications from abroad, they will stop being considered as well. So in a nutshell, health and care workers will start from after 2028.
And also, I think as well, just like if you want to switch in country, because I think the dates that are really important for you to hold on to is the 22nd of July, 2025, where people who are coming from overseas, they can no longer, as health and social care workers, they cannot come anymore at all. And then 2028, July, it's for people who are wanting to switch into this category. So if you were a dependent, if you were a student, if you were on postgraduate visa in the UK, you will not be able to switch into the care work route from the 22nd of July 2028. It will be closed to new entrants. So it will be closed to all new entrants. But those who are already on the care work visa. So if you are already on it and you are extending, you can still carry on. It's not that it will end on the 22nd of July 2028. And if you already had a visa, you will not be able to extend. You will be able to extend, but you won't be able to switch in to that category. So it will end for new entrants. That's what the government says as of now. But obviously, if there's a demand, it will be reviewed as well. But for now, on the 22nd of July 2028, they aim to close that route to new entrants who are in the UK who want to switch. But those who are already on the care route, they'll still be able to extend their visa or to continue to stay until they reach settlement. But 22 July 2025, those from abroad, they cannot come. And then another date, which has got a lot of questions here, just to answer that in advance, it's for dependents. So the date for dependents that's important for people on the care work visa is that 11th of March, 2024. That's the important date to hold on to. To make it simple for yourselves, 11 March 2024. If you arrived in the UK on the care visa before this date, or you switched into the care visa before this date, 11 March 2024, then you're still able to bring in your dependents. But if you arrived after 11 March 2024, or if you switched into the care work visa after 11 March 2024, then you're not able to bring your dependents. Unless, I think Wayne mentioned this, they were born in the UK or their sole responsibility. So that's an exception that's there. Like, so if a child was born in the UK or you are on a student visa and you're switching and you've got a child who no one else can look after, then that's now an exception, which wasn't there at the beginning. So that's important as well to note. But generally, just generally, 11 March 2024, if you came in before or switched into the visa route before, you can still carry on with your dependents until you reach settlement. But after that date, you can't. And that's the major change that was done last year. But this time, what they've extended to is the other categories as well. So not just care work visas. So they've extended to those on the temporary list, shortage list, like construction, hospitality. If people come in those categories, they also can't bring their dependents. So they've extended it to other routes as well. So that's perhaps the difference.
Thank you. Yep, so we've got another question here. So someone stated that their visa is expiring next month. What is their fate? Arslan?
Can you just repeat the question? What is the fee?
So someone said, I have my visa expiring next month. What's my fate?
Okay. If your visa is expiring next month, you've still got the opportunity to be able to renew the visa before then by getting a new COS. The changes are coming in from the 22nd of July 2025 this year. So if you're already on the COS, if you're already on the same route, you can still switch into that route to a different COS. So if you're able to find a COS, then that should still be okay.
Thank you. Okay. And then we have another question. Just bear with me for a moment.
Margaret, I'm just going to answer a question while you're looking for it on what do you mean till settlement? And somebody else asked, is settlement still 5 years? And they've also asked, so is it going to be 10 years to get indefinite leave or will it be 5? So at the moment, it's still 5. It hasn't yet changed to 10. As long as you've got 5 years continuous residence as a skilled worker, healthcare worker on the care work visa. So as of today, those are that those are the rules. It's still 5 years. It hasn't changed to 10. There's a recommendation to change the qualifying period to 10 years. But just like with all the other rules that have been introduced, most of them are looking forward. Something Wayne said about that is not retroactive. So if you look at most of the rules, they'll say from the 11th of March, we're given notice that anyone who comes in cannot come with their dependents after a certain date. So with the 10 years, we don't know how they're going to introduce it. So no one knows yet. We don't know. So at the moment, settlement is still 5 years. It may change to 10, but it might be changing to 10 for people who are joining after a certain date. Or people who are coming in as skilled workers after a certain date. And it most likely won't be for people who are already on that route. Because there's something that's called like legitimate expectation, that when you first came onto this visa route, you expected to settle after 5 years. You made plans to come into the UK and work in this sector for 5 years. And that was what you had planned, and people would have made those plans with that knowledge. And so they had an expectation of that, which is a valid and legitimate expectation. It's a principle in law. So usually when they implement changes such as these, they would do it going forward to say, if you're going to join, you must know that I'm coming here and I'm going to do 10 years until I get indefinite leave to remain. So I have to stay in this role or in this category. So when the Home Office issued the statement of changes about the length of time, we will then know. But for now, anyone who tells you that it's changing on this date is it's 10 years for everyone, they're lying to you. Nobody knows because the government hasn't said. So we're waiting, just like how they've issued this statement of changes, and the last one before that, they issue out statement of changes and give the details of the changes every time. Like, so with the 10 years, we will know when we know. But for now, as of today, the 10th of July, 2025, the period to settlement for a care worker is 5 years. That's the law today. That's what we know today. But as you've seen, things change quickly. Sometimes we don't get notice. Sometimes things are done in a haphazard way. So we just have to wait for that around the 10 years. So that's what I meant about to settlement. I meant five years. And yes, you can renew if you're still on that route. I think people are asking this question a lot. And no matter how many times we've answered it, I think people just keep asking it about, am I still able to renew after 2028? I think we've answered it. Wayne, do you want to answer that one again? Because you did cover it in detail. So it might be worth for you just to repeat it.
Yes. So, as stated earlier, after 2028, the care work route and the senior care work route is being closed. So they will be no longer eligible for the skilled worker route, and it will be the end of overseas recruitment from 2020 July 2025, and the care work itself is ending on 22 July 2028. So I hope the picture on screen makes it clear. You can take a screenshot of that or just go through it. It's
So
pretty
I think maybe there's a so in country switching, if you've explained that, but for
yes.
someone who says, will I be able, I think the question was around switching employers. So if you're on the care worker route and you want to switch employers after 2028, you can, but you can't switch into the route. I think that's the difference that maybe people are not getting. So you cannot switch into the route as a new person from like a student, graduate visa, or dependent. But if you are already on that route, you can switch employers. So yeah, so I think that was probably the area where they were not clear on that. Yeah.
Yeah,
So
thank you for clearing that
thanks.
up.
Perfect, thank you. So I think we've got time for a couple more questions. So someone had asked if their dependents were now grown by 2028, could they apply for indefinite leave to remain?
If the dependents are above the age of 18 by 2028, those rules would still be the same. So, as Rumbi was just explaining, the 5-year rule or the 10-year rule, it would still be under the 5-year rule. And as long as they're not living an independent life and they're still dependent on you, then that should be okay.
Okay, thank you. So we have got another question. So someone has stated that since the government has removed the displaced worker system that was running, have they made different provisions for displaced workers or those being exploited to switch to different employers easily because most employers now do not want to sponsor and most roles say no sponsorship? I feel there is a huge gap slash contradiction if the government wants the employers to sponsor from within the UK, as employers say that.
Yeah, 100%.
Sorry, did you guys
What you're
get all
saying.
of that? Or would you like me to repeat that?
No, I can see it on the screen.
Okay.
Yeah, I would definitely agree with you 100% that there's a gap, contradiction, that what the government are saying and what they're implementing, it's not leveling up. So at the same time, they're saying that they're trying to protect the displaced workers, but at the same time, they're restricting the routes that are available to them. And especially for the sponsors that are trying to give the COSs, they're not making it easy for them as well, because at the moment, there is a delay with granting the COSs. So it is kind of a limbo. There's no easy answer to that. They, in answer to your question, have they made different provisions for displaced workers? They haven't. It's just the initial one that they done when sponsors were getting their license revoked and they were referring individuals to the local authorities. That's the same provision that's still in place. They haven't added anything additional. But you're 100% right that it is a bit of a gap in the system, which we are actively addressing.
Perfect, thank you. So yeah, I think we've still got time for one or two more questions. So someone has stated that they are in a status of a graduate dependent. Am I allowed to switch to the 6131 with my spouse, who's presently on a spousal, I think that says spousal visa? If yes, am I allowed to bring my kids from abroad to here after the 22nd of July 2025?
I think on that question, we need a bit more clarity on what the spouse is doing, what her visa exactly is, because that's not really clear. If it's referring to being a skilled worker, if she's a skilled worker, then that also depends when she was on the skilled worker. If she came as a skilled worker before the 11th of March 2024, then she can have dependents on her visa. But if she came after that date, then she cannot. So there's just a bit more clarity needed for that question.
Okay, that's fine, thank you. Yeah, let me try and see if I can rack up a couple more questions as we've still got some time left. Someone has stated if, sorry,
Yeah, carry on.
did someone want to say something?
No, carry on, carry on.
Okay. So someone has stated if you have a gap because you couldn't secure a job, then secured a COS, how will that affect your indefinite leave to remain?
So providing that you had valid stay during that gap, then that should affect you in the long term when you come to your ILR. If there was a period where you were on a COS and your visa expired, and then you were staying for 1 week or 2 weeks or however long it took you to switch over to the visa, then that could potentially affect you. That could potentially start the timeline of the 5 years again from when you went on the new visa. but assuming that you didn't overstay and it was just a gap in employment, not a gap in your visa, when you get to your ILR, you shouldn't encounter any major issues as long as overall you have been working as a skilled worker.
Margaret, I just want to answer another question, which someone asked way before, asking if you can switch from dependent, if you were a dependent of one person, and then can you switch to a dependent of another person? So, if you came as a dependent of A, then you separate from A and you move on to B, and then you want to be B's dependent. So technically, yes, you can switch if your relationship ends and you can be sponsored by another dependent. But the Home Office is aware that people may not, so they question the genuineness of both relationships. They may question your first relationship to see whether that was a genuine relationship, and they can ask for more information and evidence around that. They would also want to see that your relationship has ended. And then moving on to the second relationship, they would also scrutinize it much more. They may call you for interviews, they may ask for more evidence. Because there's been a lot of abuse of the system. So the Home Office has become more aware of some of the abuse. And so they are scrutinizing applications more. And there have been instances where when they're making these queries, they then come to the conclusion that the first relationship was not genuine. And they've even cancelled the visas for both spouses. So the sponsored worker and their dependent, if they suspect that there's been marriage fraud or there's been sham marriages or there's been any form of deception. So it's really important if you're going to move fast like Wi-Fi in your relationships, you just need to be mindful of the fact that there will be quite a bit of scrutiny around whether your relationships were genuine or not. Because if you're moving from one person to another really quick, then it calls into question whether or not you were in a genuine relationship in the first place. So just be aware of that and be mindful of that in making your applications and in your relationships as well, where they end too fast. So the Home Office is quite strict about that now, because even if you're trying to bring a sponsor from abroad, a new dependent from abroad, when you had another one before, they're also refusing quite a lot of them and asking for a lot of questions. Another thing that we've seen that's been happening is that the Home Office is also questioning people on return, asking about your spouse, their full name, where they work, what do they do, who's their employer, and other questions like what type of drinks do they like? Do they like coffee or tea? And they ask you, and then they can phone your spouse to ask them the questions as well. So please be very mindful of that. Yeah. Our time is up.
Thank you, Rimbi. Yeah, so unfortunately, we have just run out of time in terms of questions that we are going to be answering. However, we will do our best to answer some more questions on our social media. So that is Tulia Group. So make sure to follow us on there and check out for any more latest updates. However, or if you do have further questions, please do feel free to book a consultation to have a one-on-one time with our solicitors. So that's either Rumbi or Aslan. So that is it for today in terms of the webinar. However, I do just want to make people aware of a couple of other things that we do have going on at Tulia at the moment. So we have the Hands of Justice campaign launching on the 23rd of July 2025. So we are inviting you all to participate in that and join in. So feel free to register. So you can do that via our website. So that's tulia.org.uk. Or you can find further information on our social media. So that's also Tulia Group. So this is in collaboration with Amnesty International. So don't miss out. And Wayne, if it's possible for you to just move on to the other slide. Perfect, thank you. We also have Tulia's conference for healthcare workers on visa holders coming up on the 29th of August 2025. So if you are in Coventry or if you are in the surrounding area, but you do want to attend, don't forget to grab a ticket. They are free. There is further information on our social media on that as well. So that's Tulia Group again, and on our website. So that's tulia.org.uk. Don't miss out. There will be food, a lot of good discussion, and a lot of great speakers to hear from. So that is it for today. We just want to say thank you again for coming and joining. It has been very insightful. So I just want to say thank you to Wayne for presenting today. I just want to say thank you to Rumbi and Arslan for answering questions from us. And
Margaret, sorry, before you go, sorry. Before you finish, we're just chatting with Arslan. There's a lot of questions around the salary for carers. So we wanted to clarify that before you go. It's not £17 an hour. It's not 41,000. Those are for the other categories of skilled workers. So it's not, it does not apply to carers. The salary for carers is, if you're already on a care visa now, is £12.21 per hour. But if you're a new entrant, it's £12.82 per hour and 25,000 a year. So it's not the 41,000. I think there was a bit of confusion around that. So that doesn't apply to the areas which are on the on like a health and care visa and the senior carers. So that doesn't apply to people on that. So there's been a lot of questions around that. It's still the 25,000. It's not 41,000. No one would ever be able to employ anyone. So we just needed to clarify that so that there's no misunderstanding about that.
Perfect.
So thank you.
Thank you. Yes, so we are just rounding up now. I also just want to put out there that for those that are looking for legal advice, that are on a COS holder, that are healthcare visa holders, we do host a free legal drop-in every Thursday at the Methodist Central Hall in Coventry from 2 to 4 p.m. We will be there today, so please do try your best to come by and attend and come and see us. The Tulia team will be there. And again, if you are looking for immediate legal assistance, we do urge you to book a consultation with us, and this will be via our website. So that's tulia.org.uk. And yes, that's from 2 to 4 for the legal drop-in in Coventry. But yes, so thank you again, everyone, for attending today. And we wish you a very happy day. Thank you so much, everyone, for coming.
Thank you,
have a nice day.
Thank you, Margaret. Thank you. Bye.
Thank you. Bye-bye.